action to be taken by the town board about the determination announced under Title IV of the Town Ordinances with respect to the request made by MRED Cummings pertaining to the hours of operation for its approved Walgreens and the legal opinion of Attorney William P. Dineen of Crivello Carlson. I think Mr. Dineen is in the audience.
I am here.
Perhaps,
You want me to sit over here?
I think that'd be great, yeah.
Okay. Any particular place you want me? Or?
Your microphone.
And they're all on.
Yes.
Yeah, if you can sit on the end of those boards.
Sure.
No, I'm at this table,
Oh,
I'm sorry,
okay.
because that one doesn't work now.
There's a switch.
You are on.
If I can sit. Good evening.
Evening, thanks for coming.
Thank you for the invitation.
First question, Mr. Carlson, did you have an opportunity to prepare anything in writing?
I did, but it's really, it's just a sort of a summary.
Okay.
Just to back up, as you know, I was invited, I was contacted by Supervisor and told me that the board voted to invite him to give an opinion. He sent me an email with the question, and I think I sent you a copy of it, and brought along.
Thank you.
Sort of a summary of the questions, my initial answers. Thank you. You're welcome.
Thank you.
But as I discussed with you, as well as the supervisor, the sharpness of the time and the amount that you had budgeted for my opinion would make it difficult for me to complete a full opinion and come to the meeting. And in discussing it with you and the supervisor, I felt that you would probably get more value for your money if I came to the meeting, because I suspect that whatever opinion I wrote out would generate possibly more questions. And if that's the case, I think it would be easier for me to be here to address them, rather than you getting back to me and saying you need a further opinion or something of the sort. So I think with that background, I don't have a full written opinion, but I am prepared to, answer the questions that were posed and provide you with an oral opinion. And I provided this with a summary. This really isn't what I would call a legal opinion, but at least it's something that will assist you in following along with what I'm going to be addressing.
Fair enough.
And just for a little bit of background, my name is William Dineen. I'm an attorney. I'm of counsel at Crivello Carlson in Milwaukee. I have been doing municipal legal work for a little while. As you can see by the color of my beard, I've been practicing for a while. And I was asked to address 3 questions, and one of them was, and this is all related to the application by the developer for the Walgreens that came to the village, the village board meeting late last night. It came to the town,
And just a real quick question before we get into that. I just wanted some background information, if we could, before we get into the meat of it.
yeah, and feel free to ask questions at any time.
You are a municipal attorney, I suppose?
Yes, that is the overwhelming majority of my practice.
Okay.
I've been representing municipalities since 1978. I've been a village attorney in a couple different villages. I'm still a village attorney in 2 villages, and that is the focus of my practice. Yes.
Okay. Any towns that you represent?
No, I do not represent any towns.
When were you first contacted by Supervisor Vansky?
Probably on or about October 9th, maybe.
Okay.
Or 10th. It was, I don't specifically recall.
Fair enough. And I'm not going to try to make this a Spanish Inquisition.
No, I don't remember, but it was a couple days before I heard back from him that the town board had voted to authorize an opinion, he called me and asked me whether I'd be willing to give such an opinion. And I said, well, who are you asking? Are you asking on behalf of yourself, or is this going to be on behalf of the town? And he said, well, it'll be on behalf of the town. I said, well, obviously I would need to know that the town has authorized that and that they want an opinion. So clearly, I am here to give an opinion to the town. You know, this is not an opinion for Supervisor Bansky or any individual. I've been requested to give an opinion to the town regarding these questions.
Fair enough. During that initial conversation with Supervisor Bansky sometime in the 9th or the 10th or 11th or whenever that was, did you give him an indication of what your preliminary thoughts were, a preliminary opinion?
Well, very, very preliminary because I didn't have any facts.
Okay.
And I clearly said to him, it sounds like there might be some issues that would need to be addressed. I said, without knowing what the facts are, and I haven't been retained to give you an opinion, anything I say right now is worth what you're paying for, which is nothing. I said, it is something that I would be qualified and based on experience to look into and give an opinion. I didn't give him an opinion. I certainly said, well, that's interesting. I see that there might be some problems, but once again, I had no factual information other than a very brief summary.
So there was no initial opinion given?
No, I did not give an initial opinion. I might have expressed, my view that there might be an issue,
Okay.
but I did not have an opinion as a lawyer.
Okay. Anybody else have some questions for Attorney Dineen before he gets started with his review?
I'll just ask you one.
Sure.
You never talked to me prior to that?
No, in fact, it
You've
was
never-
pretty obvious I couldn't even remember your name for a second.
Thank you.
No, I never talked with you before. I've talked with you, I think, maybe 3 times in total now, and I received two emails from you because you sent me information, and you sent me the question. I guess it was 3 emails, because you told me that the board had decided to, retain me to provide an opinion, and then you followed up with 2 more emails that provided me with the information. I believe I sent copies of all of them to the chairman, and certainly if he would give them to the clerk, she could forward them to the other town supervisors if they would like them. They're clearly public record in my opinion, but that's a subject that your town clerk could address if anybody asks for it.
Thank you. Anybody else? Well, let's get on with it then.
All right. Well, I think you all see the questions, and because obviously the people here in the audience don't know what they are, I will address them. I will, actually articulate them as I go through this. I just want to kind of address a little more background here. The first thing that, well, let me state the first issue that I was asked to look at is, does Title IV afford the MRED petitioner, and that's the developer of Walgreens, the ability to appeal or review, or is the action by way of an adopted motion of the board an unreviewable item? And let me state that the proper way to address that issue is to start by looking at the town's ordinances and then at the statutes, and that's exactly what, and of course the documents that were sent to me. I don't know if you want me to go through what documents were sent, but I will tell you that I think I saw all the relevant documents, and if anybody thinks I didn't see something, I know it'll be a little hard if I don't actually list them all, but I will be more than happy to go through that or discuss any particular documents. But I saw the The town board, I saw the minutes of the July 11th town board and plan commission meeting. I reviewed those. I reviewed the minutes of the August 22nd town board meeting. I reviewed the letters from MRED, and I don't know if that's how they pronounce it, but MRED, and their attorney, in which they were seeking an appeal or a review of the decision. I read Mr. Flanagan, who was appointed to be the decision, was appointed to review the decision. I read his opinion, read his decision, and I read, of course, the town ordinances. I read Title IV. I read I looked at the zoning code. I didn't read the entire zoning code. I read the relevant portions of the zoning code. And I read the provisions in the zoning code related to the Board of Appeals. What I concluded, and I think we need to look at Title IV, and I presume that you don't necessarily carry around copies of it with you, but that's where you have to start. And Title IV is titled the Administrative Determination Review Ordinance or Chapter. The request by the attorney for MRED was for a review under that section of the ordinances. And based upon that request, I believe the town chairman then appointed Mr. Flanagan to do the review. And he did it and reported back to the board and issued his decision on September 30th. Or at least that's when it was filed, I think, with the town clerk. That was the date on the decision. So you have to look at Title IV, and there's a section entitled Determinations Reviewable. And there's also a section entitled Determinations Not Subject to Review. And that's really where I started my analysis, because the question was it subject to review? So, if you look at sub A under, that's 4-1-3, it says the following determinations are not reviewable under this chapter. A is a legislative enactment, and then it goes on to state a legislative enactment is an ordinance, resolution, or adopted motion of the town board. Based upon my review of the July 11th, minutes, the issue, of course, is the decision by the board, and I guess because, well, you all know what that is, but I'll try to do it real quickly, but the town board, back on July 11th, approved a site plan and a plan of operations for Walgreens, but added an hour restriction to the hours of operation for Walgreens. They set the time limits from 6 a.m. to 10 p.m., but they also had another condition that the drive-through could be open 24 hours. And so that was the subject of the request for the review, was those hour limitations. So that's what we have to determine, whether or not that was a legislative enactment. That was the first thing I looked at. Could that be a legislative enactment? It was adopted by motion of the town board. In construing ordinances, you always look to the words of the ordinance first. If they are plain on their face, the courts say that, that's what it is. That's what it means. The law in Wisconsin is that ordinances are presumed to be valid, they're presumed to be constitutional. Okay, having said that the ordinance is clear on its face, so that there's an argument that the review decision was made contrary to the town ordinance. In other words, that it wasn't authorized, he wasn't authorized to make that decision. The request by MRED's attorney said that they wanted a review of the administrative decision of the town board. And I suspect they had read the ordinances as well and characterized their request as a request of an administrative review. So I went on to look at sub B of that ordinance, And that subsection says, any action subject to administrative or judicial review procedures under state statutes or other provisions of this code are determinations not subject to review. So the question, if we'll just set aside that first one about whether it's a legislative enactment, let's address this second part of the ordinance. Clearly, the petitioner phrased it as an administrative decision that they wanted to have reviewed. So I looked at your zoning code to see whether or not you had other procedures. Now, under state law, if you have a zoning ordinance, the state statute 6223(7) requires a municipality that has a zoning ordinance to have a board of appeals. It's just a requirement. It's part of the state law that allows you to adopt and enforce zoning laws. So I looked at your ordinances, and yes, you do have a board of appeals ordinance, and it's essentially verbatim what's in the state statutes. It provides for a review of administrative determinations by the Board of Appeals. So I said, well, it seems like there is something in the town ordinances that would allow for an administrative review under the zoning code. So I said, well, why, what does that mean? So I then went on to, I want to just do a little, take one step back. There was a lawyer in the Milwaukee area called, his name was Jim Baxter, and this was kind of his favorite subject, administrative review of zoning decisions, and he'd been somebody that we had hired to be a special counsel in a number of different communities over the years, and I attended all of his, I don't know if I attended all of his, I attended many of his seminars, and I went back and started digging through, some of the materials that I had read and some of the seminars I'd gone to, and sure enough, my research led me to the fact that the Wisconsin Supreme Court, in a case called League of Wisconsin Women Voters, ruled that when you have a request, when you have a situation where you don't know whether or not it should go to a Title IV, Title IV is actually what is known as a Wisconsin statute, Chapter 68 Administrative Review. There's a section of the statutes, Chapter 68, it allows municipalities or towns that have procedures for administrative reviews. And in your ordinance is essentially the same, it's consistent with the state statutes. And your ordinance on your Board of Appeals is essentially the same requirements that are found in the state statutes in 6223, which is the zoning enabling statute requiring the Board of Appeals. So the League of Wisconsin Municipality, the League of Women Voters, had to decide when you've got somebody wanting a Chapter 68 review in a zoning, arising out of a zoning decision, where are they supposed to go? Are they supposed to go to the Board of Appeals, or can they have a Chapter 68 administrative review? And the Supreme Court held that no, a review by the Board of Appeals of a zoning decision is the exclusive way to have your administrative review. You can't use the Chapter 68 procedures. So there's still a couple sub-issues here, I think, that have to be looked at. Was it an administrative decision? I think an argument could be made that it was, and perhaps an argument could be made that it wasn't, that it was legislative. I think that you don't have to make the argument, you really don't have to decide whether it was a legislative decision, because at this point in time, it was considered to be an administrative review by the petitioner. It was apparently considered by the town, at least by referring it to, the Chapter 68 of the Title IV process. But it went, in my opinion, it shouldn't have gone to your Title IV. It should have gone to the Board of Appeals. The petition didn't ask that it go to the Board of Appeals, didn't file an appeal with the Board of Appeals. What that means, I'm not entirely certain yet. because we're still, I guess if you want to look at this as maybe chapter 2 in the story, you know. I don't know if there's going to be a chapter 3. That's, going to be determined in part upon what the town board wants to do, based upon what I'm advising you. But in any event, I did additional research, I read additional cases to see whether or not a decision by a governing body, when it's reviewing site plans and operation plans, could be considered an administrative decision. And in the case that I just referred to, the League of Wisconsin Women Voters, and in cases that they cite to, it's clear that the Wisconsin Supreme Court has determined that when a body that has zoning powers makes a decision about how to apply or enforce or impose conditions with respect to their zoning decision, it is considered that they are administering the zoning ordinance, as compared to when you are possibly rezoning a parcel. That's considered to be legislative. If you are amending your zoning code to change, your zoning uses or districts, that would be considered to be legislative. If you're amending your zoning map and changing districts, those would be legislative. But when you have a code section and you have an applicant who is seeking approval of some sort, it's considered by the courts. They've ruled in a number of cases, some similar to yours and some that are somewhat different, but they've said that you are administering your ordinance under those types of situations. So I think the better argument is that in this particular case, I think that they were right when they were claiming that they were seeking a review of your administrative determination of how to, whether to add hours of limitation to the plan that was submitted. But where I think the train got off the track, so to speak, it went on the wrong track to the wrong station. So, based on the League of Wisconsin, I'm sorry, I keep wanting to call them the League of Wisconsin, the League of Women Voters. So used to calling, dealing with the League of Wisconsin municipalities, it just slips in. It's been a long day, I'm sorry. And anyways, the Women Voters decision clearly says that you have to go to the Board of Appeals. You can't go to Chapter 68. There's a slight difference in that, and every, I'm sure that the applicant will, say that this is distinguishable. I mean, every lawyer who gives an opinion, it's usually basing it upon, the statutes or the cases that they read. And I will tell you, every case that comes after a case, there's always some way of distinguishing it. There's always something different. The names on the case are at least different. But it's my opinion, based on what, my research and review, that the League of Women Voters is this controlling law in Wisconsin. And that it basically, in my opinion, means that Mr. Flanagan's decision was inconsistent with, the state law and the Board of, and your ordinance requires an appeal to go to the Board of Appeals. So, I did some more research just to, try to, confirm that I'm not missing something. I looked at McQuillan and American Law and Zoning. McQuillan's is a treatise on municipal law, and looked at the American law. We have the full, set of American law and zoning in our office, and I reviewed that. I looked at additional Supreme Court decisions, which I'm not going to bore you with, just citing them, but I am satisfied that there, that the law as articulated by the Supreme Court and the League of Wisconsin, the League of Women Voters, is still the law in the state of Wisconsin. I think that unless you have any questions, the answer to the first question is that I don't think that the decision or I don't think the town board's decision to impose the hour limitations back on July 11th. I do not think that was reviewable under Title IV. And that's what I was asked to look at, and that is the conclusion I've come up with. And I'm articulating to you, and I'm more than willing to answer any questions on that, or if you want, I can try to finish up on the other two, or we can address any questions or issues regarding that first one right now.
I think let's take a couple of questions.
Sure.
if you're willing. My first question is, so your opinion is that this should have gone to the Board of Zoning Appeals rather than a Title IV action?
That is correct.
Okay. And your opinion is also that this is an administrative decision?
I think that's the better argument.
Okay.
I'm not saying that I'm just saying that I think that if you reach that conclusion, you can address the question to a logical conclusion. When I was looking at this and analyzing it, yes, I could have done additional research to see whether or not I could support, reach a conclusion on the sub-8 of the town ordinance. When I started looking at it and I just came to a preliminary opinion about it, I then went to sub-B and then I started looking at that, and that's when I started remembering that there is case law and that there is law on that second subject area, and so I really went more into that. I will tell you that I could find no cases on point that specifically ever interpreted the wording that we're looking at under sub-A of your Title IV legislative enactment. I reviewed Chapter 68 and the statutes annotated, and the only case that I found under the Wisconsin statutes on Chapter 68 was the League of Women Voters. And I did not find a case that addressed specifically what a legislative enactment is under Chapter 68. I did find cases, though, when reviewing under the zoning cases, the differentiation between administrative versus legislative. And so because of that, I think that's where I focus, really focus, because I think it answers the question about whether it should have gone to Title IV. If I concluded that it couldn't have been a Title IV review because it was a legislative enactment, but I came back and said I couldn't find any cases to support it, I think that would be, I wouldn't have been doing my job and, thoroughly vetting this. But the question was, and I didn't really answer it real well, or at least as directly as maybe you wanted, but I'm not saying that it couldn't be a legislative enactment, but I'm saying I don't think you need to I don't think the decision has to be made, or that you want me to spend any more time researching or expanding upon my opinion in that area.
As we sit here tonight, your best, I hate to say that, use this, best guess is that it is administrative. Well,
I'm an attorney, and I wouldn't call it a guess. I will clearly admit, an attorney's opinion, unless agreed to by judges, is still just an attorney's opinion. But it is my professional opinion, and so it is more than a guess. Because I spent a considerable amount of time looking at it.
Fair enough. So, yes to administrative decision, likely administrative decision. Is that fair?
That's
okay.
Fair, yeah.
Is there then, your opinion then also is that it should have gone to the Board of Zoning Appeals rather than through a Title IV?
Yes.
Okay. Is there a timeline for the Board of Zoning Appeals?
That's a good question, and in attempting to nail that down, I was not able to determine that there is a specific time, but it's by law within a reasonable time. So ultimately, I can't give you an answer, since any attempt would be based upon speculation as to whether or not, what's a reasonable time. Well, first of all, nothing has been requested for an appeal to the Board of Appeals.
And just so that from my own understanding, let's make the assumption that the petitioner would have gone through the Board of Zoning Appeals, is then if he wasn't happy with that outcome, is a Title IV review the next step, or
No.
what is his next redress?
No, the statutes, and it's probably in your zoning code too, but if you go through an appeal or a hearing before the Board of Appeals, the next appeal is to the circuit court.
Okay. In this case, and let's make an assumption that the Title IV was used improperly, that's your opinion. So what is our redress for that, making the assumption that the Title IV was used improperly?
Well, that's where, and I appreciate your providing me with this intriguing and interesting legal situation. It's not entirely clear, and in part it's going to be based upon what the board wants to do. So, if I am correct, and a court would agree, and whether or not a court will ever be asked, I have no idea. But if I'm correct, that means that the decision of Mr. Flanagan is not in effect. And it would mean that the town board's decision of July 11th to limit the hours is in effect. So, you've got a couple possibilities that could flow from that. And maybe more than a couple, but at least a couple that I could envision. One, you don't like the uncertainty, and I'm sure that if the property owner, and I suspect the gentleman in the tie out there might be an attorney, because I took mine off before I came here, but he's the only other one here with a tie, so perhaps he represents them.
You got it the other way around.
Oh, I'm sorry.
Tylus too.
Oh, okay, I apologize, but in any event, I suspect whether they agree or don't agree, and I'm confident we won't hear tonight, or at least if we hear something, they'll get back to us, but whatever. No property owner wants uncertainty either. And the town, I'm sure, doesn't want uncertainty. So, if the town doesn't want uncertainty, I guess there's a couple possible ways of dealing with that. One is, you could file a court action to seek a declaration that the decision of Mr. Flanagan was not correct, and a declaration that the town board decision remains in effect. Or you could say, well, based on Mr. Dineen's opinion, we're going to take the position that the decision of the town board is up to July 11th is in effect, and that when the property is open for business, you will remind them of that they're subject to our limitations, and that if they violate them, you could take the position that you'll enforce the ordinances. I would have to assume the property owner would not be pleased with that, and would either bring a suit or try to convince you to, not do that. This is all speculation. I have no idea what they're going to do. You probably at this moment in time don't know what you're going to do, and because you're a collective body, you can only do it, by having a vote. And so it's difficult for me to give you good answers, because I really don't know what the various players in this situation are going to do tomorrow and the days after that. But what I mentioned are certainly some potential possibilities. I don't have any idea about where they're at with respect to starting construction or anything. Based upon my review, but I didn't look at any of the issues about building permits and all that stuff.
Sure.
I'm assuming that the town has or will be issuing a building permit, that they'll be starting the construction. Your decision on limiting the hours doesn't in any way preclude or limit them from starting, the project. But then again, I don't know if there's something in their financing arrangements that would cause a problem. I've seen nothing to suggest that they would be precluded from starting, the project, and that the question about hour limitations wouldn't really come into play. until they're open for business and want to start operating at the hours they would like to operate.
Does anybody else have any questions on pertaining to question 1 before we have Mr. Dineen move on?
I do,
Please.
or at least I think they pertain to question number 1. The first one, I want to thank you for coming and spending a little bit of time to enlighten us tonight. Appreciate that. Can you tell me, you make reference to the case law, this League of Women Voters of Appleton versus Outagamie County. Do you know what the basic issue in that matter was, that there was a claim of harm by administrative zoning decision? Do you know what the underlying issue was?
Well, yes, I do, and I'd be more than happy to, I'll tell you, and if you want the copy of the decision, I can send it to you
Briefly,
tomorrow.
10 words or less.
Well, I can't do it in 10 words or less, but I'll be brief, okay? It involved a large, it was a project to build a sort of a shopping mall in Outagamie County, and they had to do a number of things and get zoning, some approvals from the zoning board up there. They basically didn't go into a lot of details about what the specifics that they were seeking, because mostly it dealt with the property owner. It was the League of Women Voters wanted to stop this project, okay? They went to court and they sought a court order requiring that the Outagamie County, the board that was, I guess was the Outagamie County Zoning Board, the County Board of Agriculture Extensions, Educated and Zoning Committee. They covered a lot of things up there, I guess. They wanted that board to conduct a Chapter 68 contested case hearing when the developer, General Growth, wanted to do this project and get the approvals that they needed from their zoning committee. And because they wanted to do cross-examination, they wanted people under oath, they wanted to go after them, okay? And expose them for whatever bad things that they thought, you know, this developer was going to do. So they actually went to court right away and sought a court order requiring it to be declared a Chapter 68 proceeding. The court, and required all the extra things, including witnesses under oath and depositions, cross-examination. The court said, no, you go ahead, zoning board, have your hearing, and if people are unhappy, you can come back to court and we'll deal with it later. So as it went on and the county approved it, they then filed suit again, and actually then they sought a Chapter 68 review at the county level, and the county wouldn't give it to them. And then they went on and they kept litigating it, and ultimately one of the issues the court addressed was, what is the proper way to review this? And the county had a Board of Zoning Appeals, and the court ruled that that's what they should have done.
Okay, thank you. If I could, just two real quick things that pertain to issue number 1, and I think this has already quite largely been answered, but I want to just make sure I understand it in my own words. First question, I guess, relates to this. I represent to you, no surprise, this town board adopts a lot of motions, okay? I think in this whole process, a number of people have concluded that all adopted motions are legislative enactments because that's kind of how it's definitionally presented. I guess my position has been, no, not all of our adopted motions are legislative enactments, and based on what you have said, I understand that you would concur with me. We adopt many motions that are not legislative enactments.
Let me put it this way, I'm not going to spend any time disagreeing with you.
Okay, then we can move on from there. And a legislative enactment, and I'm inclined to agree with you when you're saying this really is administrative, but it may have gone to the wrong place. But I mean, legislative by its nature means the making of a law, doesn't it? I mean, isn't that the essence of the definition?
Yes, but I think it's broader than that, but
Okay.
that's certainly the source of it, you know, adopting And I don't know whether you adopt budgets by ordinance in the town or not. I'm assuming you don't, but some communities, some municipalities adopt their budgets by ordinance, and therefore it's clearly more but I think there can be other decisions besides, purely legislative, like adopting ordinances that are legislative in nature. Making decisions about money could certainly be legislative in nature, even though it isn't by ordinance and it's by motion. There are many, I think and it'd be hard, certainly in my opinion, probably, well, let me just say, I don't disagree with your statement, but I didn't really, come here prepared to address all the possible, legislative enactments, but just from my experience over the years, many of the actions of a governing body are going to be legislative in nature, but not all of them.
Fair enough, thank you. That's the only questions I have on the first one.
Anybody else? Anybody else? Let's move on to number 2.
Well, number 2 was really, I think I in effect answered that. The question is, if the action is reviewable, did the time for action on the request expire? I understood the question to mean, if it was reviewable under Title 4, did the time expire? Well, I'm not going to spend a lot of time talking about it because I don't think it was reviewable under 4. I think it may have expired in any event, but I don't think I need to spend any more time on it. I don't think it's really an issue that needs to be addressed at this time.
Fair enough. Any questions from the board on question 2? Then let's move on to number 3.
And let me read the question. Does 13-2-4 provide the board the authority to consider and approve hours of operation, and then in parentheses, frequency and duration, close parentheses, for the business operation? And clearly that's the zoning code section is 13-24. And let me just get that section here so we can talk about what that means. Title 13 of the town code is your zoning code, and chapter 2 is general provisions, and that's where the section 13-2-4 is found. It's entitled Site Plan and Plan of Operation Review. It starts with, and I was asked, I guess, to look at that section, not necessarily any particular subparts, but the entire section. Well, the first part is sub A, and it's got a purpose, scope, and intent. And it states that the Town Plan Commission and this is the second paragraph, it says the Town Plan Commission and Town Board, hereinafter in this subsection referred to as the town, shall approve, conditionally approve, or reject the detailed site and architectural plans, period. Then the next sentence, the town shall review the site, existing and proposed structures, architectural plans, neighboring uses, utilization of landscaping and open space, parking spaces, etc., etc. I'm not going to read every word in there. Let's go to C under that ordinance. It says that's entitled Plan of Operations. It says no use shall be approved until the town and staff, and don't forget, town is defined previously to be the Town Plan Commission and Town Board are referred to as the town. So the Town Board is part of that definition of the town. Until the town and staff has reviewed / approved the plan of operation application form. That shall include, and with respect to the question, sub 3 there is the frequency and duration of all activities, and sub 8, the season, days and hours of operation. All right, so the question is, can the town board consider and decide whether, what hours of operation can be for a business? Now, my understanding, well, let me answer by that stating, in my opinion, yes. The ordinance, you read the words, it's on its face. It says that it can't be approved until the town, and that includes the town board, has reviewed, approved. Now, what would be the purpose of putting reviewed and approved and then listing these activities under these subparts if the town board had no discretion to approve these? It would be, in my opinion, a meaningless ordinance. I think that it's implicit that if you're going to have an ordinance that gives them the power to review and approve, it gives you discretion. The discretion in all zoning decisions has to be based upon purposes and criteria and the scope of your ordinance. And there's plenty of case law that says that you look to the general requirements in your zoning code to to help facilitate these types of decisions. The question about whether you make a good decision or a bad decision, or whether it's reviewable or not, are different. That's a different question than whether you have the power and authority to do it. In my opinion, you do have the power and authority. This body, the town board, has the authority to make those types of decisions. I'm not going to cite cases because there's no specific case that says that you have the authority to approve a plan of operation limiting hours. But there's no doubt in my mind that there's many cases that clearly authorize decisions made by governing bodies that have imposed conditions. One of the cases cited in the League of Women Voters is the Nodell Cadillac and Glendale case, and that was a case where the Plan Commission in Glendale imposed, conditions, and that there was a fight over whether or not they had the power to do that, and the court ruled yes, they do. I'm of the opinion you have that power. How you exercise it is, another question, but I wasn't asked whether or not you exercised it, properly. And I was asked whether you have the power, and I believe you do. And by my stating I didn't answer the other question, I don't mean to imply you didn't.
With regards to that, you mentioned conditions a number of times. The Nodell Cadillac case, that was not a permitted use, that was a conditional use where the town or the village of Glendale had the ability to impose conditions within the conditional use. In our case, what we're looking at is a permitted use, and that's my first comment. And then my next comment would be, or question rather, where in C, sub C, does it say that we have the opportunity to review and approve a plan of operation, which includes all of the things that you mentioned. But where in there does it say that we have the opportunity to modify that plan of operation?
Well, I think it's absolutely implicit that if you can approve frequency and duration of activities, and if you can improve hours of operation, you are not straitjacketed into receiving a plan of operation that's totally within the control of the applicant or the petitioner and left with no discretion but to approve it.
Certainly not, we could deny it.
No, I think you can go in between. I don't think you're straitjacketed to only approving or only denying. I think you can impose conditions. Once again, they have to be, they are subject to the overriding requirements of your zoning code. They can't be arbitrary and unreasonable. They can't be unrelated to, your zoning requirements.
You mentioned another interesting term that can't be arbitrary. So if the town, under similar circumstances, had approved 24-hour operation, would it be arbitrary for us then to deny it?
Well, it would depend upon the facts of the two matters and to whether or not there was a rational basis for making a distinction. That's just beyond the scope. I'm not giving you opinions about theoretical cases, which maybe aren't theoretical, but I don't know about them.
Fair enough.
guess if I could just follow up, and I think you used a couple of keywords, or my question to you was going to be whether the town, going along with your opinion on that, can consider approved hours of operation, whether they can do it selectively. That's in essence the question that has been asked, and I have some particular concerns about it as it applies to this matter. And I think you mentioned arbitrary. That would seem to me that there would need to be some good and grounded reason for doing so. I mean, I guess even just a little bit of a hypothetical thing, for example, Town of Waukesha is a great place to do business. If Crivello Carlson decided that they wanted to open a law office in the town of Waukesha here and build a building, and you came to us with a plan of operation and said, we'd like to do business in your town, the frequency and duration of our operation is going to be Monday through Friday, 8 to 6, and the town simply say, gee, we think 10 to 2 would be adequate. I mean, wouldn't that be, I understand that's a hypothetical, but I mean, can we have the power to do that type of thing?
You might have the power, but if you had no basis in your zoning code to impose those conditions, because I think you'd be hard pressed to, demonstrate or have anything in a record that would show that having a law office open, for only at those hours would be consistent with your zoning ordinances. Because let's say if we had a business that created problems, now maybe people don't like lawyers, but I don't think that we create zoning problems. I don't think we generate a lot of heavy truck traffic to our sites and other things like that. So, but I understand your point is, how would the town be able to justify limiting, a business just to arbitrary, because I think 10 to 2 would, yes, we would view that as being arbitrary, although actually some of our staff would be perfectly happy. We check to see if they're making campaign contributions to the town board, but no, all kidding aside, you would have to be able to tie those restrictions to something that our business would, some consequence or effect of our business would be having upon the neighborhood, the adjoining property owners, or the town by, whatever detrimental effects. Whether, maybe we would disagree, but if you had evidence that the type of clientele that we attracted to our offices, insurance companies and stuff like that, was just causing a lot of problems in your community, maybe there would be a basis for it, but you would still need to tie the restrictions to, the code, to the requirements and the what you're hoping to accomplish in your zoning ordinances.
Okay, do you, and maybe you haven't looked at this, is there the decision that the town board took to restrict the hours of operation? Is there anywhere that you tie that to our zoning code, or have you not looked at that?
I did not look at that. I only looked at whether or not, I'm aware of the restrictions because that was what I was asked, that was what the board did. But no, I didn't look, I did not have access to any additional information. I got a copy of their plan of operations. I got a copy, I reviewed the plan commission minutes, I reviewed the town board minutes, but I did not look beyond the sections that I'm talking about right now with respect to that issue. I read the letter from the attorney for MRED to the town, and they listed a lot of issues that they felt suggested that the town's decision was arbitrary. But I didn't try in any way to delve into that to see to determine whether they're right or wrong. I didn't feel that was within the scope of what I was asked to do.
And I think that's fair. And I've got, I guess, one last and follow-up question, and absolutely that's fair. That wasn't part of your assignment. But I guess the question I've got, and I differentiate on this issue about considering and approving hours of operation, frequency, and duration between conditional uses and permitted uses. That's part of my takeaway. We certainly have examples here where we have, I think, properly exercised the regulatory authority of this town board, and with recommendations from our town plan commission to impose upon the hours of operation for conditional uses. I have been on the plan commission for in excess of 25 years. I don't have a photographic memory of every action that we have ever taken or that the town board has taken. And I may be mistaken, but I cannot think of an instance in which this town board, and the town plan commission, town board have reviewed hundreds of plans of operation in that duration of time. I cannot think of a single example in a permitted use in which the town board has not approved the requested hours of operation from a business. So I guess my question to you is, and somebody may give me an example or examples to prove that wrong. Assuming that's true for a minute, is there anything about the history of this that is in any way precedent-setting or relevant to the issue at hand?
I understand what you're saying, but that really, what you're saying would be addressed to whatever body were reviewing the administrative decision of the town board. And right now, there isn't one, so I don't think I can answer your question. I understand it, but.
Okay. That's fair. Thank you very much.
Anybody else before I speak up? Vansky? So, would it then be, and I don't know if you would be in a position to make a recommendation, would it be your recommendation then that this issue go before the Board of Zoning Appeals for the town of Waukesha?
I don't think I could make that recommendation. I mean, could it? If you're asking could it, I'm not sure, or if you're asking it should it.
Let's
It
ask
sounded
both
like you were
questions.
asking should it.
Let's start with should, or let's start with could, and then let's go to should.
Well, first of all, only a party that's aggrieved by a decision has the right to go to the Board of Appeals. So that's a question that can only be answered by either the property owner or anyone else who felt aggrieved by the decision.
I asked that incorrectly. I'm not asking if my question is not if the board should take it to the Board of Zoning Appeals. Rather, should the petitioner have asked for a Board of Zoning Appeals review rather than a Title IV review? And then I have a follow-up question to that is, under the assumption and belief, which we know is true, that the petitioner, the aggrieved party, asked for a Title IV review, is it incumbent upon the board, or in this case me, to select somebody to do that review and move forward?
I'm not sure I followed the second question. I don't, at this point in time, you're asking, it's incumbent upon you to ensure they have an appeal?
To follow through with their request for the Title IV review.
Well, I think you did. You did follow through with the request for Title IV review, and you appointed Mr. Flanagan, and he issued a decision pursuant to that. I will tell you that there are literally hundreds of cases that I've, read, and some that I've been involved in, where I've defended municipalities who had officials make decisions or tell a member of the public or one of their residents they could do certain things, or even issued permits. And the municipality later discovered that, oh, that was a mistake. And the law in Wisconsin is that regardless, the municipalities, it's very hard under Wisconsin law to bring an estoppel claim against a municipality, because the courts have looked at it as, well, wait a minute, the residents of the community expect their town or their village or their city to only do what's lawful. And so the courts have said that, well, even if the city attorney or the village attorney tells a developer, yeah, it's okay, you can build there, yeah, that's all right. There's case law that says, no, if the law was that they weren't entitled to the permit or they couldn't build that particular project, the courts have said, no, you can't stop the community from actually enforcing the laws that they have on the book. So I think, I mean, in a roundabout way, I mean, you did respond to their requests, and I understand, they asked for a Chapter 68 review. They got a Chapter 68 review. I'm just saying that that was, in my opinion, a mistake. And I don't think that precludes or stops the town from still enforcing its laws, which, in my opinion, based upon my review, was that the town board's decision remains unaffected by any review at this time.
Can I ask a follow-up question then? Taking that as assumption for a minute, I have no idea what the applicant might or might not do, but would it be their prerogative to ask that this matter be presented to the Board of Zoning Appeals? Do they have the prerogative to do that? Does the board have to
No, the
bless
town
that?
board does not have to, in my opinion,
So
the
they can
town
make a
board
direct
doesn't have
request to
to
do that?
permit it, authorize it, or do anything of the sort. You have an ordinance already in place that provides that appeals can be made to the Board of Zoning Appeals.
So applicant's direct choice.
It is their choice. An aggrieved party can make that decision. Just to flip it a little bit, let's assume that, let's assume the decision was different and you didn't impose any hour limitations, and but a bunch of people had shown up at the town board meeting and said, you know, this is going to harm us, this is going to decrease our property values, and if you, and they would potentially be the aggrieved parties, and they could file, they can come to the Board of Appeals. Now, obviously, that's not what occurred, but it's, the aggrieved party doesn't necessarily have to be the party that's applying for the permit or the approval. It can be other people who are affected by the decision. But it's up to the aggrieved party. They're the one who own the quote claim that they're aggrieved. They have to be the aggrieved party, and they have to be seeking an appeal of an administrative zoning decision. Those are the two essential elements of to get before the Board of Appeals. Now, there's other things, variants, and all sorts of other things that are totally unrelated and not subject to this whole discussion. And if Jim Baxter hadn't retired, I think I could have convinced him to come out here and done this for free because he liked this subject so much. I don't know, maybe not.
Based on your opinion, and the petitioners here this evening, and I don't know where they would stand on this, if the town board voted to nullify the proper term, the Title IV decision made by Mr. Flanagan, would the petitioner then, if we agreed to do that, would the petitioner move forward with a Board of Zoning appeal? And I mean, I
don't think the town board has any authority to nullify Mr. Flanagan's decision by itself. I think the town board, I think that it may be, if my opinion is correct, it is a nullity because it never was, he never had the legal power to make this decision because it shouldn't have been before him. But if you truly want, and if you want more certainty, a court would have to confirm that as an order of the court. And once again, I don't know if the property owner will be so concerned about this that they would go first they may not. If my opinion is not correct, and the Title IV review was within the lawful authority under the town code, you have, by statute, by ordinance and by statute, you have 30 days to appeal a decision under the Title IV. You would have until October 30th, if I'm correct on the date that it was filed with the town clerk, I believe it was September 30th, you would have until October 30th to commence an action to seek, in order to to get a court to issue an order, a judgment that there was no authority, or that it's a nullity, or to seek, if the court were to determine that it wasn't, but that you want to seek a reversal of it.
So what you're saying is the town's redress for this is we would have to sue the petitioner, basically?
Well, you would certainly want to serve the petitioner as part of that action. Yeah, it wouldn't be directly suing, you'd be seeking but yes, I guess from a layman's understanding of it, you would be on the opposite side in the case.
Or are we filing an action against ourselves, i.e. Mr. Flanagan?
Well, Mr. Flanagan is the review, the person who reviewed it. You would actually probably name him because he made the decision under the ordinance. And just as if you reviewed a Board of Appeals decision, you actually name the Board of Appeals in your suit when you seek certiorari review.
So
you would basically seek a review of the decision saying it was unlawful, and that's one of the standards for certiorari review, that you had no unlawful, it was unlawful and no lawful authority to make the decision. I would think you would want a declaratory, you add a claim for a declaratory judgment to seek in order that the town's decision was in effect. Or you can wait and see what happens. There will be uncertainty, and you will have to decide whether or not you wish to enforce your decision. If you don't enforce your decision, you theoretically have the situation where you could have other individuals that may be concerned about why you're not enforcing the ordinance. Theoretically, a resident could say, you've got valid restrictions. Why is Walgreens open at 2 in the morning? Theoretically, they would have a claim to go to court and get an order to enforce the town's decision. So unfortunately, I come here, I can give you my opinion about this, and like I said earlier, I don't know if it's, the last chapter, I'm not able to come here and say, well, here's my opinion, now that solves everything. I certainly have no incentive to come here and tell you that you've got more legal problems than you had before I got here. That's for you to decide. I just was asked to give, review these matters and give the opinions to the best of my ability, and these were the conclusions I've reached.
So it sounds like we've got a couple of different, there are a couple of different avenues that can be taken. One would be that the petitioner would file to have a review by the Board of Zoning Appeals.
That's certainly a possibility of what could occur.
The next would be that the town, and correct me if I'm not saying this correctly, the town would file in the circuit court, and we would file against Mr. Flanagan. The town will probably hire an attorney to defend him, and then hire an attorney to pursue that action.
That would be, I guess you would have to decide whether or not you want to hire an attorney to defend Mr. Flanagan. That would be up to the board.
If he's acting in...
He's not, first of all, this would not be a claim against him personally. He would have no liability under this type of a statute. There's no, these types of reviews, certiorari reviews, there's no claim for damages, but this is something you should, probably need to discuss with your town council if that is an avenue you want to pursue further. But I will tell you that Mr. Flanagan wouldn't be exposed to personal liability or expense. All that would be reviewed is his decision and whether he had the lawful authority to make it. I have no idea whether Mr. Flanagan would be concerned about that or not. I've never spoken with Mr. Flanagan, but I know that he was appointed under your ordinances. He would be, clearly he was engaging in discretionary activity in making this decision. There wouldn't be any basis in my judgment for him to be concerned about being subjected to, any damages or claims for attorney's fees or anything of the sort. But whether you would want to appoint someone to defend it or not, that would something you'd have to take up with your regular town attorney.
If he was acting in the interests of the town, wouldn't it be incumbent upon the town to hire somebody for defense for him?
You'd have to decide how you wanted to do that. You could. You'd have to decide whether you want to defend this decision or not. You might decide you don't want to defend this decision. It's possible someone else will step in and want to defend this decision.
Any further questions for Attorney Dineen? Looks like no. Thank you.
Okay.
Thank you.
Thank you.
You're welcome. If anybody wants to, is having trouble sleeping, I can forward any of the extra things that I talked about but didn't include. But you've got my email address, and I'm going to go.
Just one quick one. This, if we were to support that your opinion that this is an unlawful action, and that status or that finding does not have a time restriction, there isn't a holy cow on October 31st, we lose the right to claim that this was an unlawful action and to seek a judicial declaration that it was an unlawful action, we would only lose the right on October 31st, given that September 30th date. We would only lose the right to file for a writ of certiorari based on the Title IV limitations. Is
Yes,
that
and
correct understanding?
I think that's correct. You would lose the right, though, to get in before the time to file a certiorari expires. If it's a nullity, if his decision is a nullity and is of no legal effect, in my opinion, you could still argue that same thing on November 1st, keeping in mind that as long as you've got a judge who agrees that you didn't have to file the cert action and that my opinion is correct, you would be all right. If you get a judge who thinks that you needed to challenge that before the time limit expires, you could be faced, you would be in a more difficult situation. I wish I could give you a better answer than that, but there is some risk in just letting it go. Whether that's a risk that you're willing to accept, you'll have to decide that. I mean, obviously there's underlying issues about what's underlying this and the cost. Those are all things that you're going to need to come to decisions with. If for any reason you are this board wants to commence an action to do a cert review of Mr. Flanagan's decision, you would need to do that fairly quickly. It would be my advice that I don't know when your next meeting is scheduled, but you would want to probably just make that decision fairly quickly. That's something you could schedule for closed session if you wanted to discuss commencing litigation. But beyond that, I don't know. I can't really give a better answer than that.
And did that process start, the Title IV and the deadlines and all that started when they filed the letter or when Mr. Flanagan provided them a response? When did when did we have the risk presented to the town that Title IV was now something that was in play?
Once Mr. Flanagan issued his decision, and it's, I know I haven't, what I'm talking about, I've got it here, let's find it. All right, it's dated September 27th, but it wasn't filed with the town, according to, which I'm assuming that is the town stamp there, received by the town on September 30th, so I'm assuming no one had notice of it until September 30th. So, because it's addressed to the town chair and the Market Town Board, so in my opinion, the time starts running on September 30th, and you have 30 days to file a cert action.
And just to clarify, prior to that, if we had said to the petitioner, we don't believe that Title IV is an allowable review, and we did not commence the review, we wouldn't have a Title IV restriction because the decision would have never been issued to them.
That would be correct, assuming, yes, based on that question, yes, I would agree with that.
Thank you.
Do we have the right to say that?
Yes, I think you'd have the right to say you don't have a Title IV hearing.
Fair enough.
I don't think you'd have a right to say you can't go to the Board of Appeals.
Anything further? Thank you.
Okay.
Mr. Laska?
John, I didn't finish my report. Can we go back to item number D or proceed after item number F?
I think let's finish this up and get this put to bed.
Sure.
Then let's move forward, and then we can go back first. Joe, how you want to proceed?
I'd like to put the item on the agenda for Thursday night.
Put it on the agenda for Thursday night next week. I'd like some time to understand what we were just provided and consider our options. I was of the belief that if this was an unlawful action, that we probably could let it sit. And if Walgreens forced the town's hand at a later date to open their doors and on a 24-hour basis, that we'd have some protection or some offering there. I think that there's a risk that Attorney Dineen presented that I had not factored into my thought process, and I'd like to kind of think through that.
So what do you want to do?
Put it on Thursday's agenda.
Are you asking to table it till next Thursday?
Sure. I'll make a motion to table this item until Thursday, October 24th.
I'll second.
All in favor?
Aye.
Opposed? Motion carries.